Welcome, everyone. My name is Ciraolo. I'm a partner at Kostelanetz and Fink in the Washington, D.C. office, and I am so pleased to be here today with Michael Desmond, who's going to spend about 20 minutes with us answering some questions and talking about the IRS Office of Chief Counsel. Mike is the 48th Chief Counsel of the Internal Revenue Service, where he oversees a staff of more than 2,000 employees, including approximately 1,500 attorneys. Mike has been serving as Chief Counsel since March 4th of 2019, following his confirmation by the U.S. Senate on February 27th of that year. As Chief Counsel, Michael also serves as the Assistant General Counsel in the Department of Treasury. Mike, we have a lot of questions today, so we're going to launch right in without giving 20 minutes on your background, which we could easily do. Let me just say that Mike is a longtime friend and member of the tax bar. We are thrilled to have him as Chief Counsel of the service. We are grateful for your public service. I want to say that up front, and thank you for taking the time to answer some questions today. So,
sure.
Let's just launch right in. And let me ask the question of the day. How are you and your team doing with respect to the pandemic?
Sure. Thanks, Caroline, and thank you very much for having me here today. This is a great opportunity to speak to a large audience of tax practitioners and try to give you a sense of what we've been working on to the extent that you haven't been reading about it in the tax press and other places recently. But this has, for us as Chief Counsel, been a busy time for us. Like everyone in the country, it's been a challenging time since March with the COVID pandemic. But I think, relatively speaking, we've been faring very well. We were able to move to a virtual environment and a telework environment very quickly. We're very fortunate that the nature of our work within counsel is fairly portable, and our attorneys have embraced that across the country, particularly in the technical offices here in Washington, in the guidance area, but also working in the field offices, supporting the exam teams, litigating the cases in tax court. So it's been a very busy time for us transitioning to that virtual environment to address the pandemic. But I think now we've gotten to a place, particularly in the field, where we've got our tax court trials running virtually these days, been able to pivot to a position where we are able to support our client and work very effectively in getting guidance out, working to support the IRS in its implementation of COVID relief provisions, and also start ramping back up on the enforcement, collection, and other activities that the IRS has been working on. So it's been a challenging time. It's been a challenging time for everyone, and obviously will continue to be. But I think, relatively speaking, we're fortunate, as I said, with having some portable work that we can transition, and folks are getting used to the stay-at-home, work-at-home environment, and all things considered, doing well on that front.
Thank you, and please extend our thanks to your team. Working cases with Chief Counsel over the past several months, we've been impressed with how much they've been able to manage while we're all navigating the impact of the pandemic.
Right.
So,
right.
So let me move on to some substantive issues. Many listeners today are representing clients who have not complied with their FBAR reporting obligations. As we know, that's the report of foreign financial and bank accounts. Most of us are generally familiar with the role that the IRS revenue agents play, and of course, the Independent Office of Appeals, and even the role of the tax division at the Department of Justice in terms of litigating. What is the role of Chief Counsel with respect to FBAR enforcement?
Sure, and as everyone knows, FBARs are a little bit different in that they're typically not a Title 26 issue. It's a Title 31 issue, so they're treated a little bit differently across the spectrum within the tax administration system. They are not deficiency proceedings and don't lead to them, so we don't have tax court jurisdiction, which is one of the principal roles of the counsel field attorneys. But we do have a role, as you indicated, Caroline, in advising the field as they're looking at examinations, issues of willful versus non-willful, helping to evaluate facts in cases and provide advice on the front end to field teams that are looking at FBAR penalty cases and trying to decide what direction to steer them in. So we certainly have a role there on the front end, just our field advice function. Also in appeals, and there are obviously mechanisms for appealing exam determinations of FBAR penalties, typically in a pre-assessment environment. Appeals is one of our clients, just like exam is, and we've got some independence rules there that we try to adhere to. But if questions do come to us from appeals, that will be along the same lines substantively as the questions we get from field examiners. We're there to answer those questions for appeals. There's also a somewhat unique role with FBAR penalties in that if they're over $100,000, they need to be approved on settlement by the Department of Justice. So if appeals is working to settle and resolve an FBAR penalty case that involves some larger dollar figures, we will typically act as the go-between between the appeals function and DOJ to facilitate consideration of those larger penalty cases and resolution of those through appeals. And then if matters can't be resolved and the assessment goes forward, we're also the conduit to referring the cases over to DOJ for collection suits, which, as I said, is required for the FBARs because they're not deficiency proceedings. So we do, in our traditional role, refer cases over to DOJ with suit recommendation letters. So that's the other role that field attorneys will be playing with respect to FBAR.
Can you speak to whether an FBAR penalty that's assessed will always be referred to the Department of Justice for suits to collect? I'm catching you off guard with this question.
Yeah, I wouldn't say that it's never going to be, and I wouldn't say that it's always going to be. Obviously, there are some thresholds and some dollar limitations. Resources are limited across the board. I think I don't know that there is any hard and fast rule there as to when we do or don't refer cases over. We're obviously selective in the use of our resources across the board. But there's certainly no cutoff point where one case will or will not be sent over. So I think it's difficult to give any kind of black and white rules anyway as to when cases will or won't be referred over.
And I think Sorry. I think it's important for the audience to know that if you're close to that 2-year window, the end of that 2-year window, the Department of Justice can act quickly. They don't need a lot of time to put together a complaint, to review a file, and to get something filed to meet a 2-year statute of limitations. So people shouldn't take comfort in getting close to the end until they're past that deadline. So,
and another dynamic, I know we have a lot of topics to cover, is that FBAR cases often develop or don't develop in a vacuum. They may also be parallel income tax deficiency proceedings, foreign information reporting penalties under the Internal Revenue Code, so they can be linked to other proceedings, some of which may have tax court jurisdiction to them. So I think that's another reason why you can't really give a hard and fast rule. These don't arise just in a vacuum. There are usually other compliance issues that are moving along at the same time the exam teams are working on an FBAR penalty case. So those all have to be taken into account.
Excellent point. Let's switch over to the IRS fraud enforcement efforts. There's been a lot of activity in this area. There's some great new leaders within the IRS focusing their strengths in this area. Can you talk a little bit about what the office is doing with fraud enforcement?
Sure, and I think this really comes from the top down. I think everyone has heard the commissioner's comments about the importance of criminal investigation cases and secondarily or relatedly fraud enforcement. I think everyone's also probably familiar with the statistics over the years. There's been a declining number of civil fraud referrals over to CI, and that's a trend that I think the commissioner and the service generally would like to see reversed. So that has led to some of the developments that you referenced, Caroline, in particular the establishment of a new fraud office within SBSC on the commissioner's side. And Damon Rowe is heading up that office. We, at the same time in council, established a fraud council, Carolyn Shank, to advise Damon and work with Damon to develop those cases. And that office has only been in place for a few months now, but is also seeing some really dramatic results. I think Caroline and Damon, together with the teams they are working with, have been making a number of presentations to probably thousands of IRS employees to educate them on what they're doing, what they intend to be doing, and also just to start giving background on what fraud cases are, what it takes to develop them, and how to move those forward. Really to try to drive home the commissioner's perspective that we turn around that declining statistic of civil fraud referrals over to CI. And even if they don't end up in referrals or cases that are taken by CI, an important role there to even develop civil fraud penalties and promoter penalties, promoter injunctions, all of that activity. So a lot of life has been breathed into that activity, and I think you see it with the office that Damon and Carolyn have established and all the outreach that they're doing. And for the foreseeable future, we'll continue to see an uptick in activity in that area.
Sounds like practitioners should brush up on their civil fraud research, case law review, and
Yeah,
taking a look at the IRM.
and I always say, and I know others on this program will probably share my view, going back to the beginning of my experience in mostly civil tax practice, but the two words I throw out in this area are one, deterrent, and one, inventory, or two, inventory. Everybody knows the deterrent effect of criminal cases. They make headlines. We've seen headlines recently on criminal tax cases. In the civil arena, for the most part, our activities are all cloaked in the confidentiality of Section 6103. And criminal cases are too, until they become indictments and they become public. But the press reports that we get and the publicity that we all see around criminal cases, I think, cannot be overstated. So that is a very high priority for us. You can't turn that into dollars per se, but certainly we all know the impact of and deterrent effect of criminal cases. And also inventory. And again, going back to the earliest days of my practice as a civil practitioner, there are all sorts of cases out there that you can take a look at and say, with a little extra effort, this could be a criminal case. So the inventory out there is plentiful. And to your point, Caroline, I think it's something that practitioners need to be aware of, and certainly taxpayers need to be aware of. There's a lot of activity out there that has been pursued civilly, or perhaps even not pursued at all, that really, if the resources allow, can be committed to pursuing fraud, and that's what this office is doing. And really looking for ways to streamline and expedite the processing of the cases, to move them along quickly, so that the ones we are to be able to develop, we can get over to CI quickly. They're not stale cases. And if CI doesn't pursue them, we can decide to pursue them civilly and develop civil fraud cases within counsel and working with them. So a lot of energy being committed to that effort these days.
And we should give a shout out to Criminal Tax Counsel, which office has been in place for a long time. They serve as counsel to criminal investigation, and I'm sure is playing a role in all of this.
They do. And just for the benefit of the audience as well, in terms of our counsel structure, and this is probably something that wasn't as transparent to me, but we do have 3 litigating divisions within counsel. We've got the Large Business and International Division, SBSE Division, which handles the vast majority of our cases. The TEGE Division Counsel, which handles our exempt organization issues and handles the litigation of those. And then you mentioned, Caroline, the CT Counsel as well, which advises CI. They are a little bit different because all of our criminal litigation is done by the Justice Department. So our CT Counsel is an advisory function, not a litigating function. But they do work with DOJ. They work with the CI folks really all through the process. So they do have a hand in the litigation, but they're a little bit different in that they're not the ones that are actually litigating cases like our other litigating divisions are in tax court.
Well, we expect to see a lot coming out of that area and keeping everyone busy on our end of the table. Speaking of promoter investigations, you mentioned, and abusive transactions, the IRS has made it clear that it's pursuing taxpayers and the professional enablers involved in abusive transactions. Can you talk to us a little bit about the service's view of the syndicated conservation easements, maybe some current stats if they're available, and just briefly, what's the landscape of the settlement options?
Sure. And just to put that in context, we mentioned the fraud office at the IRS with Damon and Caroline working from counsel's perspective. There has also been a recent development with Brendan Odell getting appointed to be the promoter coordinator for the IRS. So he reports directly to Sunita Lowe, who's the Deputy Commissioner for Services and Enforcement. So, and he's got an overarching role coordinating between LB&I and SBSC on the commissioner side. So in that promoter area, I think you see, as you do in the fraud area, an effort to coordinate that and have kind of IRS-wide jurisdiction over promoter activities and centralize those in. So, and that's always been an area that we've been very active in. Probably another area that we would like to be more active in, particularly the coordinating role of that, making sure that we are working collectively across the IRS and with counsel support and with DOJ as well. So there's always been a lot of promoter and preparer injunction activity, and you see that, as you mentioned, Caroline, in particular with the conservation easements. I think over the last 3 years, there have been more than 150 injunction actions against preparers and promoters. As I said, a piece of that in the conservation easement space as well. The preparers and the promoters, there's a sort of 2 different categories in my mind. The preparers tend to be the really kind of off the charts people doing things that are flat out fraudulent, making up deductions and those kinds of things. And those cases are probably the more numerous in our injunction activity, but perhaps equally or even more important are the more substantive cases like conservation easements that we see when those turn into syndicated and promoted transactions as presenting, as we saw even 10 years ago with the tax shelter activity, really existential threats to the tax system when you start taking aggressive tax planning and making that a syndicated and promoted transaction. So as with conservation easements and other areas, that is some place where we want to focus injunction resources. We want to focus promoter and promoter penalty resources and even preparer penalty resources. So I think Brendan's appointment there does signal increased activity in that area and increased coordination in that area and trying to move those cases along much more quickly than they had been historically. And if we're not going to pursue injunctions, then pursue alternatives such as penalties on an expedited basis, or at least expedited relative to some of the way that we handle these.
Understood. And in the microcaptive space, any thoughts in that area?
Yeah, so as people know, we have 3 decisions out of the tax court. One of them is on appeal to the 10th Circuit right now. There are several other cases that are deep into litigation or awaiting decision in the tax court right now in microcaptives. We've got some settlement initiatives in the docketed cases that I think have been talked about in the tax press. So we're moving forward on those fronts, leveraging off of the 3 favorable decisions that we've received in the tax court to try to get some of those cases resolved. And I've had some good success in doing that within the council docketed cases. So I think right now our efforts are really twofold. They're to move forward with cases that don't want to settle and be sure that we are continuing to litigate those, but also to indicate a willingness to clear out some of the cases that are there. We've got well over 100 cases pending in docketed status. And we think that the outcome of those cases is not predetermined, but determined by the 3 wins that we've had. So we are looking fairly favorably upon those cases, but obviously willing to settle cases if folks want to come in on the terms that we've offered to get that inventory cleared out and focus our resources elsewhere. So I'm really working on both of those fronts. As I said, one case on appeal to the 10th Circuit right now, a reserve mechanical case. So we'll continue to work with the Justice Department on that case. And as I said, several cases deep into litigation and awaiting decision in tax courts. So things don't.
And one message we can give to taxpayers involved in these is communicate, right? If you're in an audit, communicate with your revenue agent, have your counsel discuss these issues. If you are looking at a proposal and you don't fit squarely into it, that doesn't mean that you shouldn't start a conversation, correct?
Right. Right, and that's absolutely right, Caroline. And I mentioned the inventory that we've got within counsel of docketed cases. There is a much larger inventory of microcaptive cases being worked by exam, some making their way into appeals as well. And the IRS is working with us. We're working with them very closely to see what we can do about that. Obviously, can't take all of those cases to trial and shouldn't be taking all those cases to trial. And frankly, if there's a way to get those resolved short of them getting into docketed status, that's, I think, in everyone's interest as well. And we're also keeping an eye on evolution of those transactions. I think there's been some talk about next generation microcaptives that don't necessarily involve Section 831B. And we're certainly aware of those and paying attention to those as these transactions evolve. Typical of what we do in any type of syndicated promoted type transactions. So that activity is out there now as well.
And just a final word on promotions, we should tell the audience that it's not all about syndicated conservation easements and microcaptives. There's other promotions out there that Brendan's office is looking at and peeling away the layers and investigating. So it looks like we lost Mike's video. Let's see if he can join us back. See if his microphone is working. Let me ask the last question and maybe he can jump back in. There he goes. Okay. Final question in our just a minute or so left. Can you tell us a little bit about what your office is doing in the area of virtual currency?
Sure. We're working very closely with IRS on that front as well. I think everyone has seen our priority guidance plan has a project to expand information reporting in the context of virtual currency. Everyone has seen, I assume, the checkbox on the 1040. We just put out draft instructions about a week ago for the 2020 1040 return that moved that checkbox from Schedule 1 to the front page of the 1040. So that's in draft form right now. I think that does signal a lot of activity going forward. There has been some increased exam activity. We in council continue to work with exam when those questions come in regarding virtual currency compliance from the exam side. So another growth area for us, but one that I think we've seen a lot of activity in. The 1040, the PGP plan for information reporting does signal this is a project that will be with us for some time. So still stay tuned for more on that front as well.
Okay, great. And I know we're a little bit over, but I want to give you just a moment if you want to say any final comments about the partnership issues.
Sure. I think we could go on for probably a couple more hours on the priority project in the enforcement area, but that is one that even this week earlier I mentioned, and I know the commissioner mentioned as well. And just flag for folks on this call, I think some of what you've probably seen, our activity with respect to the K1s, both the capital account reporting, and we've just come out with some recent guidance on that front with draft instructions, and also in the international arena with the K2 and K3 schedules that are part of a broader effort to push toward greater compliance in the partnership arena. So an area that I think since BBA was enacted in 2015, we've been trying to shift resources to, working with the IRS and really pursuing what we think of, I think of as a congressional direction to increase enforcement activity in that area. So another one to stay tuned on, but I think even recently with the K1, K2, K3, things that you can see that we're doing in that area.
Excellent. Gosh, we could spend all day talking about how Mike spends his days. Thank you so much for your public service, for taking the time today. I know it's a busy day and a busy week and a busy year, but we appreciate you and we appreciate everyone who works in the Office of Chief Counsel. So thanks everyone for listening in and stay tuned for the next interview.
Great. Thanks again for having me.